All my niggas turn shooters. All my ops turn rats. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Uda. Welcome to the Uda. All my niggas from the Uda. All my niggas turn shooters. All my ops turn rats. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Uda. Welcome to the Uda. All of my niggas insane. They tryna catch 'em a stain. Young niggas putting in pain. It in the game, all for the game. Niggas ain't playing for nothing. Went in school, laying in pain. My little nigga kill my little nigga. Full-time job not to kill niggas. Jump off the...
You already know the vibes. You already know the vibes. We back with another one. You already know when it ain't no other ones, man. Listen, man, free Durk. We just gonna preface this video by saying free Durk and free them guys up out the kennel, point blank, period. Yeah. Salute to everybody. You already know. I'm going to do a quick read of this paperwork. We're just going to read it straight. I know I like to talk and give my own opinion on stuff like that. You know what I mean? But this is paperwork that I know that a lot of us want to know what the hell happened and what's going on. So Lil Durk files a motion to dismiss the superseding indictment for false grand jury evidence. And this is a full read. You know what I'm saying? It's looking like the people then tried to take some clips from YouTube or internet, and they was acting like Durk posted this. This is crazy for them to do these types of things, man. You're supposed to have all your T's and all your I's straight up. So if they made a mistake, salute to that. Hey, man, I ain't gonna blow it up. Salute to them if they made a mistake. Maybe that can help Durk in some shape, way, form, or fashion, because we know that Durk is in a bad one. He is in a bad one. And you know that they're going to try to use lyrics and different things like that. We've seen them do it with Young Thug. We watched them do it with T Stucky. That's an artist from back in the days. He was a street dude, but he did music too. And they gave him like life sentences and stuff like that, using lyrics to convict him. So now we see the big Eureka also happening now. So in this case, it's not about music so much. In the big Eureka, listen, it's like we're getting further in time now. I'm not going to talk too much, but look, in the big Rico, this is a podcast Rico now. Remember in the old Block 5 trial? In the old Block 5 trial, this was the first time we seen them bring YouTubers. Remember Trenches, remember Mickey, Truth or whatever. They brought them into it. We seen YouTubers get brought into the trial. So that was crazy. Remember, we was thinking about Young Thug. How y'all using lyrics? Then they brought YouTubers in. Now in this big U trial, they're bringing in podcasters and they're bringing in the whole podcast and the videos of what people are saying on podcasts. So this is going into the future of how these people is trying to lock people up right now. And they're going into the future with how people is snitching today. People are snitching futuristically. So if you're a young guy, you're a young girl, watch out. Make sure y'all keep your heads on the swivel, right? Don't go following nobody. Find yourself caught up into a conspiracy charge or something and find yourself jammed up. All right. Salute to everybody in the building. You already know. Let's get into the read. I'm going to maximize this. Not to see that, right? Cool. So let's just go to a quick read, man. It's a nasty situation, y'all. All right, let's get into it. All right. United States District Court, Central District of California. And it shows the United States of America plaintiff. It shows that Durk Banks is the plaintiff. And this is defendant Durk Banks' motion to dismiss the superseding indictment based on false or misleading grand jury evidence. All right. So I'm going to start the read with the full. I'm going to start it like this. You know what I mean? It's ain't about me. I just want y'all to get the paperwork and see it and y'all can screenshot it. You know what I'm saying? Do whatever y'all need to do with the paperwork because I know some of y'all don't have pacer and stuff, but so here, feel me? So look, defendant Durk Banks, through his counsel of record, moves the court to dismiss the superseding indictment against him in this matter. In the alternative, he moves to compel disclosure of the grand jury minutes and evidence the government presented to the grand jury. This motion is based on the attached memorandum of points and authorities, all files and records in this case, and such evidence and argument as may be presented at the hearing. The undersigned and the assigned Assistant United States Attorney in this matter had a meeting and conferred regarding this matter via email correspondence on April 17, 2025, as required by the court's criminal standing order and the local rules reflected therein. The parties did not reach an agreement on the issues presented herein. Okay, so they just prefaced it for us, right? They gave us the table of contents and everything. Everybody drop a like in the building because I'm not even watching the screen. This is a paperwork read, so I just want everybody dropping likes. free Durks in the chat if you think free Durk, whatever the case may be, whatever your thoughts are. I didn't put no poll in the chat, but I want y'all to just write in the chat whatever y'all feel y'all want to write. All right. So this ain't just about me or this or that. This is about Durk. You know what I mean? When we talking about certain things, it's not like a cloud chase. It's not like a personal video that I can do. You know what I mean? This is about Durk. This is about them. This is about people, families, and lives. So it ain't really about us. But yeah, man, salute to Durk, free Durk. You know what I mean? RIP Vaughn and all that. So look, boom. Okay, let's go here. Memoranda of points and authorities. 1, the introduction. The government presented false evidence to the grand jury that indicted Mr. Banks on November 7, 2024. This doc number 27. The plain language of the superseding indictment makes it apparent that the government told the grand jury that Mr. Banks, through specific lyrics in his music, celebrated and profited from a revenge murder that he had ordered, namely of SR, in August of 2022. That claim is demonstrably false. The song the government relied upon as evidence against Mr. Banks' Wonderful Wayne and Jackie Boy, a song that was recorded by another artist, Babyface Ray, and on which Mr. Banks recorded a feature for, could not have been a commercialization of Mr. Banks' alleged murder for hire of SR, as the government represented to the grand jury. That is because Mr. Banks recorded the lyrics for Wonderful Wayne 7 months before the incident even happened. The government's misrepresentation in the superseding indictment, whether knowing or reckless, undermines the integrity of the grand jury's true bill against Mr. Banks. The court should dismiss the superseding indictment against him as a result. 2, background. Mr. Banks is a highly successful and internationally renowned artist, recording artist, and performer who is known professionally by the name Lil Durk. His music and the resulting public acclaim have been reaching wide audiences since the release of his debut album in 2015. Although he built his professional reputation and profile as a dedicated, hardworking, and deeply talented artist beginning around 2012 through mixtapes and public performances in and around Chicago, since that initial album, Mr. Banks has released a total of 8 solo studio albums, not including his mixtapes or collaborative projects he has done with other artists. Mr. Banks has been nominated for a Grammy on 4 occasions, winning one just last year. In keeping with common industry practice, Mr. Banks has been signed to music labels, currently Alamo Records, who have helped facilitate his musical growth and have spearheaded the efforts surrounding the production, release, and distribution of his music. Also, in keeping with common industry practice, hip-hop artists not only release their own music, but also frequently lend their musical talents to other artists' songs through features, which are often a verse or 2 contained within the song. The addition of a feature from a more popular artist can help boost the visibility and ultimate success of a song, especially for newer or emerging talent. Relevant to the matter at hand, Mr. Banks had recorded a feature for Babyface Ray on Wonderful Wayne. Upon Babyface Ray's request, the song in question was ultimately attributed to Babyface Ray with the feature credit to Mr. Banks. Mr. Banks recorded his portion of the song in January of 2022, that being his last involvement in the song. Further production was done by producers and other industry professionals, but no changes to content or lyrics were ever made by Mr. Banks or anyone else that's associated with Mr. Banks, and all this information was readily available to the government. You feel me? Sound effect for that. Everybody make sure they drop in line. I'm just reading. Outside of the 4 corners of the superseding indictment, but important to this court's consideration of the egregiousness of the government's conduct and necessity of the relief contained in this motion, the issue of the timing of these lyrics was addressed by underdesigned defense counsels at Mr. Banks' detention hearing on December 12, 2024. To counter this argument, counsel for the government counsel for the government posited that the posited to the court that even if the lyrics themselves were written 7 months prior to the charged conduct, a version of this song was modified that added audio from a news clip of TB on top of the original song. Following this assertion at the detention hearing and unaware of any such modification attributable to Mr. Banks, under design counsel asked the government to provide what they were referring to in an email correspondence. Well, the government replied with videos that appear to be taken from recent open source YouTube searches that were in no way connected to Mr. Banks. And this further complicates what evidence, arguments, and instructions the government presented to the grand jury and will be addressed in more specificity below. So the issues over, that's crazy that they first of all went and grabbed something off YouTube. Yo, bro, you serious? Bro, they went and grabbed something off Tube. Come on, bro. Nasty work. Nasty work. It's nasty. It's nasty. Straight. It's really nasty. All right, cool. Let's get back to the thing. All right. The issue over the timing of Mr. Banks' recording of the lyrical verse in question is not one of frivolous or inconsequential value. It is quite the opposite. The government's misrepresentations about the creation and the meaning of A Wonderful Wayne are the linchpin of the superseding indictment theory of Mr. Banks' guilt. See, that's crazy. Indeed, the superseding indictment features it prominently. Following the attempted M of TB and the M of SR, defendant Banks sought to commercialize SR's unaliving by rapping about his revenge on TB with music that explicitly references audios from the news clip taken shortly after SR's unaliving, where TB screamed, "No, no," after seeing SR's unalived body. It is, in fact, the only material allegation that does not appear in the original indictment, which does not charge Mr. Banks, but appears in the superseding indictment, which does not charge him. The original content. Mr. Banks was not charged in the original indictment. Instead, that indictment charged 5 other individuals: Kevon Grant, DeAndre Wilson, Keith Jones, David Lindsay, and Asa Houston, as principal of an alleged M for hire scheme in violation of 18 U.S.C. and 924C, which is the weapon charge. In the furtherance, the possession of the weapon doing a federal crime, the possession of the weapon to further the crime, the unalived, then that's the 924C. And B and J, because people is unalived and all this other stuff. So you got a 924J. It's nuts. Just off the 924J alone, this J, 924J. See, 924 and J. With this alone, if you get this charge right here, right, and you're convicted of this charge, you get a minimum of 10 years and a mandatory 10 years. So that means the judge is like, yo, my hands are tied. I have to give you 10. It's mandatory, and it's a minimum. I can't go no lower. Boom. But they can't give you the roof of it. It's not life. They can't give you life for 924J. Why I'm knowing that, why I'm understanding all of that, especially deeper, because Cuffy Gatlin he pled guilty to a 924C and a 924J. So it led me down that road. Real talk. So free Cuffy. Boom. Right. So according to the grand jury, SR was not the men's intended victim. TB was. Their purported motive, a bounty placed on TB to answer for his involvement with the unaliving of another man, King Von, nearly 2 years prior, outside of an Atlanta nightclub. The indictment alleges that King Von was a high-ranking member of Only the Family, or OTF. I'm telling you, son, if Von was alive, Von would have been in jail. So I'm doing life, son. OTF, an organization that produced, and Durk's brother, an organization that produced and sold hip hop music from artists primarily from Chicago. Grant, Wilson, Houston, and unnamed conspirators 1 through 5 were also members of associates of the OTF. It alleges that OTF associates used credit cards associated with OTF to purchase the defendants' plane tickets and to rent their Los Angeles hotel rooms. It also alleges that the bounty consisted of money and lucrative music opportunities with OTF. The person who is alleged to have offered the bounty, co-conspirator 1, goes unnamed and uncharged after King Von's unaliving. Co-conspirator 1 made clear in coded language that co-conspirator 1 would pay a bounty or monetary reward and make or a payment to anyone who took part in the unaliving of Quando Rondo for his role in King Von's unaliving. That same unnamed individual, co-conspirator number 1, is alleged to have texted co-conspirator 3 the day before the unaliving, "Don't book no flights under no names involved with me." According to the original indictment, the day before SR's unaliving, the 5 named co-defendants, along with an unnamed co-conspirator, flew from other states to California, convened in a Los Angeles, California hotel room, purchased ski masks and secured 2 sedans, and armed themselves with magnetos, including one modified to operate as a fully automatic with a switch. So the next day, on August 19, 2022, the 6 men tailed the Escalade in which both TB and SR were passengers through the streets of Los Angeles until it ultimately stopped at a Beverly Boulevard gas station. There, the 3 men, their magnetos, at the Escalade's direction, ultimately unaliving SR. Pop. The superseding indictment. Now, the superseding indictment does charge Mr. Banks in an alleged M for hire. It names him as the individual referred to as co-conspirator 1 in the original indictment. It calls him the head of OTF as having directed the attempted unaliving of TB that resulted in SR's unaliving, as the person who placed the alleged bounty on TB, and as the person who texted and instructed not to put no flights under no names involved with me. In addition to naming Mr. Banks, importantly, superseding indictment contains only new material alleged fact that the original indictment does not. It avers that after the Utin, Mr. Banks celebrated his successful revenge through his music following the attempted unaliving of TB and the unaliving of SR. Defendant Banks sought commercialized. I said, okay, they said we already read that earlier, so they broke it back because he bought the news clip back, right? Cool, because you know they do that a lot in the paperwork because they're just bringing back facts that they think to be facts, but they quote the lyrics now. Told me they got an Addy, go, and you know that this is the shit that I'm sampling for my shit though. You know that this is gonna be in my sound effect, go, because we don't go on this motherfucker. Straight up, free my nigga Durk, nigga. Down, nigga. He said, told me they got an Addy, go, got location, go, green light, go. Look on the news and see your son. You screaming, no, pussy. Nigga, Durk is yo, Durk is wild. Durk, you gotta chill over here. It's a legend, y'all. Chill. My nigga Durk ain't do nothing, man. What's wrong with y'all trying to put an M's on Durk? Y'all niggas is wilding, bro. Durk ain't do this, man. And niggas need to chill, bro. Stop, bro. Yo, the underlying falsehood. Yo, if y'all think Durk ain't do this, man, put a 7 in the chat for God and Durk, man. Because you know Durk ain't do this. Come on with y'all, man. Not every rapper, trying to do something, man. Y'all take y'all time, bro. Straight. For the superseding indictment's allegations about the meaning of Banks' lyrics that they described SR's unaliving and referenced the media about it, Banks would need to have penned them after August 19, 2022. Utin, Mr. Banks did not, however, write those lines after the Utin. He wrote them 7 months beforehand. Attached as an Exhibit 1 to this motion is the declaration of Justin Gibson, the producer and the sound engineer, who recorded Wonderful Wayne and Jackie Boy, the song where the lyrics originally appeared. And Gibson recorded Banks' verse, which Banks wrote and recorded simultaneously during his recording sessions on January 25th, 2022. Gibson uploaded the track at 5:39 p.m. that evening, saved it at 6:33 p.m., and finalized it at 7:21 p.m. Mr. Banks' January 2022 lyrics, therefore, could not have been about SR's unaliving in August of 2022, unless the government's in prosecuting Banks on a theory of extrasensory prescience. The lyrics could not have soundly informed the grand jury finding of probable cause. So this is crazy that they even pushed this thing on that, though. Because I remember when they was pushing all of that, too. And it's crazy because I remember the producer had came out and was saying, nah, you bugging. You bugging, but this is good to see that they actually trying to file these motions for dismissing of the superseding indictment. They said attached as the exhibit to the declaration of Ahmad Sharif, the founder and CEO of Your World Music, Inc. Mr. Sharif works as a music producer and audio engineer for artists including Babyface Ray and Mr. Banks. Mr. Sharif attests that he received Mr. Banks' verse and lyrics of Wonderful Wayne and Jackie Boy from Mr. Gibson on July 22, 2022. After that date, he received no additional lyrics or modifications to the original lyrics from Mr. Banks or anyone else in his camp. Therefore, on August 23rd of 2022, Mr. Sharif incorporated Mr. Banks' verse into the track and finalized it and the track on his end. So he's saying whatever he did to the lyrics, he put them clippings on it. He put the news report stuff on it. It wasn't Bank or something, probably just a producer, probably just doing audio engineering, just engineered it up basically. But Durk already recorded his lyrics. Ben did this. So it's good because we heard them saying it because I was like, damn, can they prove this? But it's looking like they can prove this. So that's a good thing. Salute to that. Hopefully, you know what I mean, judge, look at it. But, you know, when they want you in this case like this, highly publicized cases, man, it's hard, bro. It's hard to shake free, bro. When the tiger got you by the toe, it's eeny, meeny, miny, mo, bro. It's hard to get rid of the tiger. Additionally, Mr. Sharif has reviewed the open source YouTube links that were provided through email correspondence by the government as examples of videos they referenced in the detention hearing and can confirm that the audio and the video clips from the audio of an individual yelling no reportedly from a news clip are not from the original recording. He identifies that those clips to be fan edits for social media platforms, and they are altered, fabricated, and inauthentic versions of the original song. The original authentic version of the song, Mr. Sharif confirms, does not contain these manipulated elements. He attests that creating the altered audio edits is easy to do through social media platforms, and such practices often result in misinformation and misrepresentation of original pieces of music and art. Now, the arguments. The superseding indictment is not sustainable. Mr. Banks, in the face of the fundamental factual error upon which the grand jury relied, such an error requires dismissal of the indictment under the following circumstances. First, where the grand jury returned an indictment based on the government's knowing and presentation of a falsehood. They go into the cases where this thing took place. Or second, where the falsehood of if unwittingly presented to the grand jury is of such character that it is later discovery demands redress. The court has the power to dismiss an indictment that the grand jury returned based on information that the government knew at the time to be or later learned to have been false. This is a real good point that they're trying to make here. Really, really good point, man. But you know, when you in the jaws, bro, of the shark, you know what I'm talking about, bro. Free that man. Free that man. It's great. Mr. Banks does not take lightly the request that he is making of this court. Dismissal in all cases is a drastic step and thus generally disfavored. That is especially so when a defendant challenges the nature of the evidence that the government presented to induce an indictment. They go into the cases. However, the court intervention is necessary in cases like this to ensure that a charging decision is the product of the grand jury's own decision on the grand jury's own unbiased and untainted judgment. The grand jury's independence and integrity are deeply rooted in our Constitution. It is an institution of constitutional dignity. The grand jury is in many ways an entity unto itself. The grand jury's functional independence from the judicial branch is evident both in the scope of its power to investigate criminal wrongdoing and in the manner in which the power is exercised. Unlike in a court whose jurisdiction is predicated upon a specific case or controversy, the grand jury can investigate merely on suspicion that the law is being violated or even because it wants assurance that it is not. The grand jury's independence is essential to its twin functions, determining whether probable cause exists through charge and crime and standing between the accuser and the accused. When a charge is dictated by an intimidating power or by malice and personal ill will, they go into the cases, has the dual function of determining if there is probable cause to believe that a crime has been committed and of protecting citizens against unfounded criminal prosecutions. To that end, court generally takes, it goes into that. Challenging it, and hold on, let me see. Holding that a district court may not dismiss an indictment on the basis that it was returned on hearsay evidence. Okay, so they're just going through the breakdowns of these things. This is just fluff. They're going to go into cases and show them what they're supposed to be. The court are likewise generally hands off with prosecutors who present government cases to grand juries, and they're going to go through that. It's all fluff right here, bro. But I just want y'all to see it too, so it's not like I'm trying to skip it. However, that the court's supervisory power could be used not merely as a means of enforcing or vindicating legally compelled standards of prosecutorial conduct before the grand jury, prescribing that those standards prosecutorial conduct in the first instance, just as it may be used as a means of establishing standards of prosecutorial conduct before the courts themselves. This is fluff. Let me see. However, the courts do step grand jury's functions. They're just talking about the grand jury, what the grand jury supposed to do. Let's get past that. That's all fluff. Let me just make sure something at the end is enough to call trial to charge or in merits. Let me see. Substantial right which cannot be taken away without a court amendment. An indictment returned by a legal, constituted, and unbiased grand jury is enough to call for trial. For the trial. So they're just saying that, okay, this is what they're going to fight back with, whatever they're saying. All right, cool. The false information presented to the grand jury here compels the superseding indictment dismissal. So this is crux. This is what we need to get to. So all of that was fluff. All right. The indictment's assertion about Mr. Banks' lyrics, their timing, and their meaning is false. When Mr. Banks wrote the cited lyrics, SR's unaliving was still 7 months in the future. For Mr. Banks to have been writing about SR would thus have been impossible. The only open question is how such patently false information came to be within the grand jury's purview to begin with. One answer is that the prosecutors who prepared and presented the government's evidence knew that the evidence was false, and that's crazy. But you know they knew this, but they did all of this to make their case stick. You know how it go, bro. They trying to put their thing together, bro. They trying to get warrants, orders, and all types of stuff. That's all they care about, bro. Straight. Let me see where we at. Government's evidence that was false. Okay. Another is that the prosecutor who presented the evidence did not know it to be false, but the witness who conveyed it did. We got to break that down. Hold on. They didn't know it was false, but the witness who conveyed it did. And third answer is that the evidence was obtained and presented with reckless disregard for patent falsity. So, So as explained further below, regardless of the answer, dismissal is warranted. The false information prejudiced Mr. Banks in the grand jury's proceedings. Mr. Banks pauses here to address a threshold issue, materiality. The defendant is not usually entitled to relief from irregularities in the grand jury's proceedings. He is where the irregularity resulted in sufficient prejudice. they're going to go into a case. Prejudice is sufficient to require dismissal if it is established that the violation substantially influenced the grand jury's decision to indict, or if there is grave doubt that the decision to indict was free from the substantial influence of such violations. And they're going to quote another case. The false information here easily clears that threshold. As described above, the lyrics were one of only two pieces of evidence that the superseding indictment cited. This is one of the things. This is critical. They really came with two things to tie him in with, and this is one of them. So it's like, what are we doing here? That's crazy, though, bro. This is crazy, bro. This is crazy. So the other thing that they probably pushing is that what he made the phone call. No, he made the text message to the other person to say, don't use my name on my things to use. You know what I'm saying? What else they really got on him? This is what's tying him in. That so-coded text message that they said, Durk, number one, said, yo, don't use my name on my credit cards and don't book nothing on my flights. Obviously, they're using that to tie him into those guys. Because without that, how are they going to tie him? They just, okay, they're part of my clique. Don't matter. So what? You feel me? Then this is the next thing. Obviously, they're trying to push to tie him in to the whole M plot. It's nasty work, bro. They might be able to prove that he wasn't talking about no crazy shit on that text message. Imagine they'd be able to prove that. They might spring Durk, son. Straight cheese. They might spring Durky, yo. Listen. So look. They say, look, see, false here in the threshold. So as above, only two pieces of evidence that side against the bank. The other was the text message. Exactly. I didn't even read that, but I'm so slow. I'm slow. The other was the text message that discussed the names and under which the flight should be booked. Man, I'm telling you, that's what they're using, bro. If he could do something with this, bro, he might be off to the races. And it was the only piece of evidence that was, as the superseding indictment portrays it, at least directly linked to Banks and SR's unaliving. More to the point, the lyrics are one of the only two differences between the superseding indictment, which charged Banks, and the original indictment, Doc 1, which identified him only as co-conspirator number one for the grand jury not to have been substantially influenced by that evidence in its decision to indict him, is inconceivable, which makes a lot of goddamn sense. And it also, let me just see this little subtext, and it also must be noted, as stated above, that Mr. Banks is an internationally known recording artist in the genre of hip hop. The question of materiality to this evidence must be also considered an unknown nature of how his status as a celebrity, his particular genre of music, and the worldwide breadth of his audience was presented to the grand jury by the government. This is how they get to hold you, and this is how you don't get bail. You see what I'm saying? So when they mention in this part right here, they gonna say all of that. Okay, cool. That means he got influence. That means he could maybe tamper with a witness and do things like that because he's a famous person. But when they saying all of this stuff like that, they trying to say that this is how they get your bail, remand you, get your bail revoked, and this is how they don't get you no bail. You say like, nah, man, look, man. They hit you with all this dumb shit. Facts. Because he's a celebrity. He could go to trial from outside, bro. What happened? Well, you can put me on a home thing. Look at Young Boy. Young Boy was on probation over there chilling in Utah, wherever he at, in Grave Digger Mountain. Come on, bro. So what? Dirk can't be in Grave Digger Mountain? Not his own Grave Digger Mountain. I'm talking his own crib, not Grave Digger Mountain. But he could be in his own crib, son, while he awaiting trial. But they ain't trying to do that. The court should dismiss the indictment because the government presented false evidence to the grand jury. I agree. Returning to the matter at hand, the court must determine whether the government knew that the assertion regarding Banks' lyrics was false at the time of it presented the case, or whether the government subsequently discovered it to be so. If the government knew that the evidence to have been false when it was adduced, then it had a duty to correct it. And it shows where maybe they corrected it in a case where it happened, right? Defendants may establish such grand jury abuse by demonstrating that the prosecutor obtained an indictment by knowingly submitting perjured testimony to the grand jury, which they did. Do they knowingly? Of course they know. Come on, they know that song ain't come from no Durk. Come on, bro, it didn't come from his page directly. What? Like, come on, this is music. This is song, shows you how much they're reaching and dipping into music so much that it's going to start getting really vague. You could just be doing a song about some other shit and they could tie you into some next shit talking about you talking about that. This is getting weird. Court held the conviction knowingly obtained through the false evidence violates the 14th Amendment due process clause to establish. Okay, cool. This is just showing that this court right here, this case right here, what happened in the case. Okay. The amended violated. Oh, let me see. The amendment is violated when a defendant has to stand trial on an indictment which the government knows is based on partially on perjured testimony. Cuffy was in a situation like this then. They obtained all that shit with Tammy, and Tammy was going against her affidavits and all that other shit. So it's somewhat similar to that. When the perjured testimony is material and when jeopardy has not attached, when the prosecutor learns of any perjury committed before the grand jury, he is under a duty to immediately inform the court and opposing counsel. And if the pre-jury may be material, also the grand jury, in order that appropriate action may be taken. Were the court to determine, however, that the prosecutor's duty to correct a false assertion regarding Banks' lyrics is not implicated here, it should still dismiss the indictment. The only way for the court to hold that the prosecutors has no duty to correct the factual error before the grand jury would be for it to find that neither the prosecutor nor the witness had no cause to know that they were traveling on a patently wrong inference, but that would mean that neither the prosecution nor any witness took time to determine whether Banks wrote the lyrics and when he wrote them. Rather, the prosecution, they might have played themselves. The prosecution appears to have assumed a connection between the lyrics and a H and presented that assumption to the grand jurors, having never investigated whether it's plausible. If that is the case, dismissal is proper under the holding in Simango. Another case. Jesus Christ. Or maybe, no, this in Simango, the ninth. Okay, cool. They're going to break it down for this. I love them. They breaking this whole shit down for us. In Simango, the Ninth Circuit affirmed a district court's dismissal of an indictment because the government had secured it in a manner that seriously threatened the judicial process, even if prosecutors had not relied on perjury. There, the government secured an indictment based on a prosecutor presenting a hearing transcripts, which concealed that most of the testimony that the grand jury was to consider came from the prosecutor himself, along with the prosecutor's own impressive report. Damn, bro. All right. Okay, so that's just showing another case. At minimum, the government's likely overstepped. We already know they did that. You already know they did that. I want to know what the hell they're going to say. It stands to reason, moreover, that given in the tight turnaround 21 days between the original indictment and the superseding indictment, a prosecutor here, as in Simango, would have introduced the transcripts from the proceeding on the first indictment, or since the same grand jury returned both indictments, a prosecutor could simply have asked the grand jurors to recall the evidence from the earlier proceedings to which the lyrics could have been added and emphasized. Okay. Mm-hmm. They just on about the lyrics, huh? They just really rewording. It's just rewording and rewording the same shit, bro. I'm just trying to see if anything else sticks out that we need to be saying, because they just saying the same stuff, you know. She doubling down on the argument regarding the meaning of these lyrics, even when confronted at the detention hearing with the evidence that proved what is contained in the indictment is factually impossible. The counsel for the government could, at that point, have made efforts to correct this wrong as their duty, but instead chose to posit it as a new argument about the overlaid audio clip that was also factually incorrect. Again, easily made clear with just, come on, son. Crazy. They could have did that. But they wanted him so bad, and that's why they played themselves, son. They was fiending, bro. Fiending for Durk, son. They've been fiending for Durk ever since the old block shit, son. Them niggas been fiending for him, bro. And that's why they kind of jumped out the window right here. You know what I mean? If they waited a little bit and just try to get the shit right, probably could have been smooth. But right now, hiccups. But you know, when they got you, even with these hiccups, look at Young Thug. The whole case need to be thrown. The judge was doing Gainesville and all that, was doing all type of wildness. Instead of them throwing out the case, bro. Yo, Brian Steele and everybody like, come on, y'all. Come on, y'all. Throw this out. Please, man. Stop. They took the judge off the case and still tried to keep it going, bro. Like, come on, bro. It's crazy work. If the court is uncertain whether the false information and the government presented to the grand jury requires dismissal, the court should order the government to produce the transcripts and evidence of the grand jury proceedings. They should. So what they gonna do? Under Fed R Crim P, that rule permits that the court authorize disclosure of a grand jury matter. I'll keep that in my mind. Let me see. Made request to Durk's already made requests to the government, but they refused them. Let me see what happened on TMZ. The defense sought clarification by email about exactly what the video the government was referencing that featured both the TMZ news footage and the Wonderful Wayne lyrics. The government responded that additional discovery would be forthcoming, but it provided 2 links to examples of the reference video that first was posted by a user with the handle of OTF Edit 3. Get the hell out of here, bro.
Oh, no, you can't be serious. That's some bullshit right there.
Yo, son, you know these people ain't on social media, bro. Come on, son. Keep it a gangster with me. You know these people ain't on social media, bro. OTF Edit. You know that be one of them little edit pages, bro. Keep it a gangster with me, bro. Keep it a gangster. Nasty work. Nasty work. Yo, these people be trying to get you. And the second one was posted by a hand of My Mixtapes. Okay, My Mixtape was just that mixtape thing. You know what I'm saying? My Mixtape, where you go listen to the music. So whatever. So they took the news clipping from TB. Damn, that's crazy. Let me see. I gotta go to the last page. Hold up, y'all. Hold up. In conclusion, right? In conclusion, let's see what they're saying. That's just a little bit of this conclusion. These niggas is foul. Look at conclusion, bro. All of that paper, bro. Look at conclusion. Conclusion like this. Come on, conclusion supposed to be like this, homie. A prosecutor, no, but you know, sometimes you just make your conclusion short and sweet, though. They say a prosecutor who knowingly secures an indictment based upon false information or who allows a falsely obtained indictment to persist roots the grand jury from its central protective functions. That is clearly what happened here. For the foregoing reasons, the court should dismiss the superseding indictment against Mr. Banks. In the alternative, the court should compel disclosure of the relevant and underlying grand jury proceedings. Yeah. But yeah, I think it make a lot of good cases, man. I think they make a lot of good points. I'll tell you the truth. Will it happen? That's a whole nother case, bro. We don't even know, man. It's a whole nother situation. Will it happen? Who knows, man? I don't know, but salute to everybody. I don't even know who dropped likes. I don't even know what's going on in there. I just did this read just to get it out. I was going to read it from last night to y'all just to get this on the board. You know what I mean? Because I got other stuff that I need to do, other paperwork reads, different stuff that I need to do. I'm still getting into the BMF St. Louis later on today. And we're going to be going into a couple of case reads as well. Quintaris Smith. We're going into Quintaris. We're going to go into AD, real top as St. Louis players. You know what I mean? They say that Q was the one that really got the plug going on, that really put St. Louis on the map in a way before Big Meech. You know what I mean? So I've been going through some of those roads. That's where the Cuffy Road and all this road and this Big Meech Road has led me. It's led me way down the road. So salute to everybody that's in, I mean, that want to get some of that information. I appreciate y'all. Make sure everybody's dropping a like, subscribe.
All my niggas from the Hooters. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer.
Yeah, man, make sure y'all are subscribing to the channel. We got a lot going on. I've got a lot of paperwork that I'm going to be reading. So listen, everybody drop your like, subscribe to the channel, and you already know the vibes. Ooda, ooda, ooda. Always on.
My niggas turn shooters.